Welcome, everyone, and thank you for joining us today for our program, the Proxy Solicitation Process in Public Company M&A. Go ahead and advance to slide 2. My name is Larry Parker, and I'm the Vice Chair of our corporate section at Mullen. I'm based in our Richmond office. In my years of experience, I've provided strategic advice throughout the M&A process, specifically for providing creative solutions to complex structures, pricing, and legal issues to the benefit of my clients. Today, I'm joined by my colleague, Will Halliday. Morning, Will.
Hey, Larry. Good morning, everyone. My name is Will Halliday, and I'm a partner in our Tyson's office and also a member of the corporate team here. I work with public and private companies on all stages of their growth and particularly help out on high stakes strategic transactions like mergers and acquisitions and growth financings. Worked with companies in a variety of industries, including technology, government contracting, and financial services. Very excited to be here with you today. Next slide.
So a little bit of housekeeping before we get started. Please use the Q&A feature on the bottom of your screen to submit questions. We'll answer all of your questions, time permitting. If your question isn't answered during the presentation, we'll reach out directly after and make sure that you get a good answer. If you have any audio or technical problems, please use that same Q&A feature and we'll help resolve it. We'll receive a copy of this presentation along with a link to the recording shortly after we complete the presentation. Next slide, please. So, Will, what are the proxy rules?
So the federal proxy rules are set forth in the Securities Exchange Act of 1934, as well as Regulation 14A promulgated under that Exchange Act. And what they do is regulate communications by companies that are soliciting proxies, legal proxies from a shareholder. And in particular, they really regulate two documents, and we'll talk about both of those today, a proxy card and a proxy statement. So the proxy card, and I've got a simplistic image of one there on the right-hand side of the screen for you. A proxy card is soliciting a shareholder's proxy to appoint John Doe, here in this case for Acme Corp, and John Doe is very likely a director or officer of Acme Corp, to represent and vote the shares at a meeting in accordance with your wishes. And they're indicated as such under Proposal 1, whether you're for, against, or abstain on that particular matter. And John Doe reflects those votes when they go to take a tally and vote your wishes. And that's what a proxy does. It's a solicitation of that exact proxy to vote how you want to be voted on these proposals. We'll talk much more about the proxy statement. The proxy card's a pretty simple document, short. Proxy statement, far longer. And is your company subject to the federal proxy rules? The answer is yes, if your company has a class of securities registered under the Exchange Act. There are really two scenarios you find yourself registered under the Exchange Act. Section 12B applies to companies that have a class traded on a national securities exchange. For example, the New York Stock Exchange or NASDAQ, or under Section 12G, which is essentially a mandatory registration process for companies that meet certain size thresholds, in particular the size of a shareholder base. For example, 2,000 shareholders of record or 500 shareholders who are unaccredited investors is a common threshold for meeting that registration requirement. Next slide. Larry, so we've talked about the sort of the overarching process of obtaining shareholder approval. What are some of the common examples where companies need to go out and solicit the approval of their shareholders?
So the most common in the public company context is a merger. And that could be either the acquirer or the target needing to get shareholder approval to consummate the transaction. The acquirer, frequently in the case where they're issuing more than 20% of their own securities as transaction consideration, or the target in just about every merger needs to go get shareholder approval. And you see some of the other instances where shareholder approval might be required via proxy. Next slide, please. So, Will, who gets to vote?
Who gets to vote? Record holders get to vote, and but it's very common for owners of publicly traded securities to not actually own their own shares. It's very common to own those shares in what's called street name, where your brokerage firm actually owns the shares and they own them for your benefit. And so when that happens, there are procedures. Exchange Act Rule 14B-1 is part of it, where those brokerage firms who hold these shares in street name have to forward proxy soliciting materials to you and include voting instruction forms. In other words, gather your vote in terms of how they should vote the shares that they hold on your behalf. I've also included this legal proxy terminology. If you are a beneficial owner and you hold your shares through a brokerage account in street name, you nevertheless can still show up at a shareholder meeting and vote, but you actually need sort of reverse permission. Even though they're your shares, so to speak, to begin with, you have to get approval through a legal proxy from your brokerage firm back to you to then show up at a meeting and cast your ballot in person. It's called a legal proxy. It's sort of slightly confusing because it's using the same terminology. And in terms of there are some instances where a broker can vote even without your instructions, and that's what I've included here in this second set of bullets. And the New York Stock Exchange Rule 452 walks through those, and it really delineates between so-called routine and non-routine proposals. So for routine proposals, if you are a beneficial owner and you don't provide instructions to your brokerage firm by a certain date as set forth in those instructions, then they can vote your shares on those routine matters at their discretion in accordance with their policies. They cannot do that for non-routine proposals, and a merger proposal is a non-routine proposal. So if you don't vote your shares as a beneficial owner on a merger proposal, then those shares will go unvoted. And that will be reflected in that particular instance as a broker non-vote, where a brokerage firm, if they're able to vote on another proposal in the proxy card, but can't vote on a merger proposal, that's a broker non-vote, because there is no instruction for them to vote, and they have no authority to vote on their own. Next slide.
So before we go on to this next question, I want to ask you a question about the previous slide. So in a garden variety public company merger where the target needs to get a specific threshold of the shares outstanding to vote in favor of the merger, what is the effect of a non-vote?
It's effectively a vote against the transaction, right? So as you outlined, when you have to get an affirmative vote of a set threshold, maybe it's 2/3 of all your outstanding shares, those are actual affirmative votes you need to get. And so if somebody abstains or if they have a broker non-vote, those do not go in the affirmative category, and so they do not help you achieve that 2/3 vote. So they're effectively a vote against the transaction.
So in a proxy statement, what type of information is typically included?
So we touch first on the proxy card, and now that much larger document, the proxy statement. It really takes one of two forms. So let's start with the Schedule 14A. That's on the left-hand side of your screen. That's the standard proxy form. And that walks through a bunch of information about the meeting and the proposals in place. So for the meeting, when is it? Where is it? How to join? Is it virtual? Is it in person? It clarifies the record date. Do you hold shares on the appropriate date, such that you actually can get notice of and vote at that special meeting? It includes information about the proposals themselves, detailed information about the proposals, and what the thresholds necessary are to approve them, and how votes are counted. Kind of like Larry, like your question about broker non-votes. What is the effect? And that would be walked through in the proxy statement. Appraisal rights, very commonly to have appraisal rights in a merger scenario. And it walks through those and any procedures necessary to exercise appraisal rights. Interests of directors and executive officers, beneficial ownership table from Regulation SK. There's all sorts of information that goes into this lengthy proxy statement. On the right-hand side of the screen, Form S4 applies when you have an acquirer who's going to issue shares as part of acquiring the target and use shares to pay for the target. And so that is the disclosure mechanism that you follow rather than Schedule 14A. And it covers much of the same material, but includes far more because it is also serving as a registration statement and prospectus for the newly issued shares of the acquirer. So there's quite a bit of information that goes into that, including about the buyer as a prospectus. Next slide.
Will, how long does it typically take after the definitive agreement is signed to matriculate through the proxy process?
Classic legal answer, it depends. And there's a lot to think about, and a lot of thought goes into the timing of obtaining the shareholder approval through the proxy process. I've included here a couple of some key timing considerations to be aware of, like the broker search requirement. So as a public company, you're going to have street holders, like we talked about, who hold on behalf of other beneficial owners. And there's a procedure to contact and make an inquiry of those brokers to get detailed information. You know, how many shareholders do you hold on behalf of, and details about their holdings. And that has to be done 20 business days before you set the record date. So there's a lot to think about, and that's obviously a lengthy period of time as you're going to set the record date. Filing the preliminary proxy statements, Rule 14A-6 of the Exchange Act says that you have to file a preliminary proxy statement with the SEC before you can then turn around and file your definitive proxy statement, except for certain sort of routine actions, mergers and acquisitions not being one of them. So you do have to file a preliminary proxy statement. The SEC has 10 days to pick that up for review. And if it is picked up for review, then that's going to add some time in terms of when they get you those comments, and then working through with the SEC on any changes and responses to the SEC. You've got to take into account the standard requirements in your in state corporate law or your corporate governance documents, just like you would if you're a private company. And adjournment of the special meeting. I mean, hopefully you go into the special meeting knowing that you have the vote. Though that's not always the case. You might not have quorum for that meeting, and you need to adjourn the special meeting. You very well might get to the meeting and you just don't have the approvals that you need. And it's very commonplace to include an adjournment proposal where you can adjourn the meeting and then get back to work, contacting shareholders and soliciting their approval until you do, until you've the adjourned special meeting, and hopefully you've got the votes then at that delayed time period. So there's a lot that goes into that, the timing considerations on this. And sort of on that last point, the role of proxy solicitors, absolute commonplace to include proxy solicitors who go out and gin up the vote. They contact, they hop on the phone, they contact shareholders. If you are worried about voter turnout for our elections for our politicians, and you'll be more worried about retail turnout on these types of proxy solicitation. So proxy solicitors have an important role to just frankly make people aware of something that they otherwise just disregard and don't rationally don't pay attention to. And so proxy solicitors can get in front of them and remind them and help them to vote. Next slide.
Well, it looks like we don't have any questions, so I'm going to ask a couple. Can you combine all transaction-related approvals into one proposal on the proxy, or do you have to have your proposals separate?
A good question. The answer is very likely to be separate, right? And so the threshold, and this is included in Rule 14A-3 of the Exchange Act, where you've got to clearly and separately identify the proposals that you're voting on. And so the SEC has come out with guidance that you can't sort of glob on an amendment proposal. If you're an acquirer and you've got to get you've got to amend your articles of incorporation, say, to increase your authorized stock to pay for the acquisition, you can't glob that into the same acquisition approval if you have an acquisition approval to go and do this to go and do this acquisition. So when it comes to sort of material corporate governance approvals like that, the SEC has come out and said you've got to keep those separately. Similarly, if you were to implement a classified board or implement supermajority voting provisions, things like that need to be kept separate. Larry, I'll ask you one that's come to mind. We've talked obviously much about the sort of public, the proxy solicitation process that applies to public companies. There are many private companies that aren't subject to these rules that nevertheless have fairly sizable shareholder bases. What, in your experience, what's the process like when you're going out to get their shareholder approval for a M&A transaction?
Well, that's a good question, Will. Uh, when you have a target with a broad shareholder base that happens to be private, you have some of the same concerns that you do in your soliciting proxies from a public company. At the end of the day, the proxy rules sort of evolved from um, fiduciary duties that corporations had to shareholders, and were modeled upon that, and just made it a lot more structured and rigid what the disclosure requirements are. So what we typically do is have an information statement that attempts to describe the transaction and provide that shareholder the material information it needs to make the decision to vote for or against the transaction. It doesn't necessarily include all of the materials that you might include in a proxy governed by Rule 14A, but it covers a lot of the same ground. Um, with, like I said, the goal being to give that shareholder enough information to vote in an informed basis. Unfortunately, in the private company world, we do not have uh, proxy solicitors that are ready, willing, and able to go gin up the vote. So that has to be done with the management's own shoe leather, and it is equally taxing. Um, but, well,
Go
it
out and
looks,
knock on some doors.
yeah, it looks like that's all we have. Thank you everyone for joining us today. Um, like we mentioned earlier, if you have any questions, please feel free to reach out to Will or I, and we will answer them. The materials will be circulated shortly after we conclude, and along with perhaps a link to the video itself. So thank you all and have a good day. Bye bye.
Bye. Thanks.